Hello everybody. Welcome to the Swiss Patent Litigation Fireside Chat. It's again the last Wednesday of the month, and here we are already at the 24th edition of the Fireside Chat. It's judicial holidays currently, still until the 15th of August. So there is no hearings currently, but the court is working, I can assure you. We received a judgment earlier today. I can tell you more about that one next month. First, a bit of housekeeping up front. As you can see, I chose LinkedIn Live this time, not the audio format. I had some technical difficulties with the audio format lately, and I could not figure out what the issue was actually. So LinkedIn Live is more stable, at least in my experience. Which is good and bad. It's good because I can illustrate things hopefully better with some visuals, and I hope that you will enjoy that. It's not so good because the interaction with you is maybe less direct than in the audio format. I cannot move you up on stage for a live discussion, but I can still see when you ask a question in the comments. So please do that. I promise to pick that up. I really promise to keep an eye on that. So moving to content now. As I said, I can maybe help the discussion with some visuals. The first case that I brought with me is litigation between Agro and 𝗤𝗂𝗿𝗂𝗂𝗃. That is the case 𝗚2021-012. And the judgment is from the 25th of May this year. So both parties know each other quite well. They have litigated earlier. And this case, again, is about electric installations on the outside of houses. So how do you install electrical stuff like sockets, doorbells, cameras, etc. on the wall of a house that carries a pretty thick insulation layer on the outside? That layer is not very stable. You cannot just screw something on that layer. So this is what this thing is for. You mount the plastic carrier onto the wall that you can see there in the middle of the illustration, and then you guide the cables through it, and then you mount the socket or whatever you like in the box at the face of it on the right side, the front side. And then there is an insulation surrounding the carrier because you want this part of the wall to be insulated too, not to be totally blank. So you don't want to be bridges for heat to just get out. But the thickness of these insulations on houses, that varies. Now, how do you do that in practice? This is where the invention comes in. The patent says that the device carrier comes along with an at least two-part insulation. You see that marked up in yellow there. Now, let's have a look at the attacked embodiment. That's actually an image from the judgment. In one size, this foamed insulation is a one piece of foam. But the other sizes, the smaller and the larger sizes, in these cases, the insulation was cut in two pieces, and then for the smaller sizes, they just took out a layer and glued the rest together. And for the larger sizes, they cut it out in the middle, and then they put an intermediate layer in between so that the thickness gets bigger. But also in that case, the pieces are then glued together again. Now, is that still an at least two-part insulation that is provided with the device carrier? That was essentially the question. The judgment holds that this is not two-part anymore. And as in most cases, claim construction was key. In that case, the judgment clearly holds what is glued together in the end is not two-part anymore. But then the next question was, well, what about the manufacturing? As I just explained, during manufacturing, they cut it into two pieces at least. Then they either took out a layer or introduced yet another layer. So at that point, they had an insulation that was made of at least 2 parts. But still, the judgment holds that this is not an infringement at that stage, because as the defendant explained, the 2 parts, or even more than 2 parts, like in this image on the slide here, those parts are glued together before the plastic carrier is then later introduced into that final one-piece part. So there was no intermediate step where, according to the claim construction that I just explained, where this plastic carrier was surrounded by an at least 2-part insulation, because when it was introduced, then it was already a 1-part layer according to the claim construction. So that meant that there was no literal infringement, and then of course the plaintiff asserted infringement under the doctrine of equivalence. Yeah, this failed already in the first step, namely because of the lack of the same function. According to the patent, the invention allows for an easy adaptation of the thickness on the spot during installation at the wall of a house. Just think of it, they can take the 2 pieces, put it around the carrier, and then you just cut off the remaining part that is not necessary when the thickness of the insulation layer on that wall is not as thick as the layer of the insulation on the carrier. Then you just cut it off at the right level, and then you're done. So the judgment holds that this advantage is not achieved by the attacked embodiment, which indeed is provided at a fixed thickness for the varying thicknesses that are known in the market, what the insulations have that are being sold. So you have to buy the right carrier for the insulation where you want to install it in. So therefore, yeah, infringement was denied, both literal infringement and also infringement under the doctrine of equivalence. I just looked it up today. The judgment is final. No appeal has been filed. So yeah, that is a quite interesting case about claim construction, what it does not mean when a claim says 2 or more pieces. Yeah, that's pretty much what I wanted to tell you about this judgment. Just looking into the comments, I can't see any comments. As I said, feel free to drop me any comments or questions you have, and I will be more than happy to pick them up. So the next case that I brought with me is not yet a judgment. It's only a quick report about a main hearing that a colleague from our office attended. That is litigation between 𝗷𝗿𝗄𝗋 and 𝗏𝗏. Infringement and counterclaim for invalidity is at stake. That's the reason why there are 2 case numbers. The case numbers are 2021-008 and 2021-016. The main hearing in that case was on the 25th of May. And yeah, the 2 parties are maybe not so well known to everyone. The clientele for these watches is well, somewhat limited. They are pretty costly. So this one here on the screen is a 𝗷𝗿𝗄𝗋 one that is definitely several hundreds, thousands of Swiss francs. The case at hand is not about this watch here. I will first show you the explanation in the patent and the actual claim on the left side. So the invention, or well, how can I put it? Here's what the patent on the right side says, why there is a need for such a watch. You want to have 𝗐𝗿 to balance springs that should have an as large diameter as possible, and they should not come into conflict with each other. So how do you build that? And that is the claim on the left side. What the claim essentially says is that you have two tourbillons, each have a cage carrying an escapement and a balance, and the cages are being driven, at least indirectly, in rotation by set differential gearing, and that differential gearing is already mentioned in the preamble of the claim. So it's not a very long claim, and it's a pretty broad claim, I would say. Now here is the beast, what the defendant builds and what the attacked embodiment is. You can see just this watch is an example of the movement. That movement is also included in other watches. On the left side, you can see it from the top. On the right side, from a window in the front, and you can easily recognize the two tourbillons. Yeah, that is the attacked embodiment. I'm just looking what Pernell says. Here it is. Pernell says it's the world's fastest double triple axis tourbillon. That's really amazing mechanics. I will show you a video. Hold on a second. Here it is. I'm not sure if I can make that play. There you go. So it's really amazing technology. You can see the whole mechanics in each of the tourbillons turning, and they don't come into conflict with each other. So yeah, that's a very special kind of wristwatches. Not my watch. I can't afford it, but there is obviously a market for that. So that was what I had on the screen. That's the attacked embodiment from Pernell. In my understanding from the hearing, we assume that it's not going too well for Pernell. I understand that no patent attorney was assisting on behalf of the defendant. Yeah, that may be good or bad. We shall see. I expect the judgment in any case very soon. As I said, the hearing was already end of March in that case. So yeah, just looking at the chat, no comments, no questions. So I will move on. The next case that I brought with me is about sunscreen. The plaintiff is 𝗪𝗏, and the brand that makes use of that invention that is at stake here from 𝗪𝗏 is 𝗨𝗹𝗏𝗂𝘀𝗃. That's a pretty well-known sunscreen brand that's sold in drugstores. It's relatively high priced, and it comes with an advertisement of sort of threefold protection of the cells of the skin, namely against UVA and UVB, and that's a special thing there. On the left side, you can see an enlargement. Also infrared A, more specifically. The litigants are 𝗪𝗏, the plaintiff and patentee, and on the other side there is Ultrasun. That's a Swiss company also manufacturing sunscreens, and that's just one of the products of the defendant that I could spot. That's also of course UVA and UVB protection, but there is also in the explanations sort of an advertisement for protection against infrared, and they use antioxidants in that sunscreen. And that is actually what the two patents are about. So the whole litigation was not infringement. It was only nullity cases. That's again the reason why there were two file numbers. It were two patents that were at stake. When you look at the claims, they are really very, very similar. So I put in bold the language that is identical in both patents, and they essentially differ only in that the granted patent of the 105 patent, the patent on the bottom, spells out a whole list of antioxidants. The other one does not. And the 𝗵𝗂𝗏𝗂𝗃 patent says it's a pharmaceutical composition for use in a method for protecting the skin. And the 𝗏𝗏𝗃 patent says pharmaceutical composition for protecting the skin from damage. So that's slight different in wording, and in terms of the antioxidants, the 𝗏𝗏𝗃 patent is much more specific. I need to make a disclosure notice on that case because we were not involved in this litigation at the patent court, but I'm representing a party in 𝗤𝗂𝗿 co-pending opposition proceedings in one of the patents. That's a third party, not involved in the litigation at the Federal Patent Court. But of course, I have a certain interest in the revocation of these patents. That's what the opposition is all about. So I won't enter into much of the details of the reasons of the judgment. What I can tell you is that the opposition proceedings against the 𝗏𝗏𝗃 patent only lately resulted in a first instance revocation at the 𝗵𝗂. And the other one, the 𝗏𝗏𝗃 patent, the oral proceedings were scheduled a few days after the other oral proceedings, and 𝗏𝗏 I'm looking for the word in English. They did not further pursue that patent. They effectively withdrew the second patent at the 𝗵𝗂. So the judgment in Switzerland of the Federal Patent Court is currently subject to an appeal. The docket is with the Supreme Court, so an appeal is pending. But an interesting bit of the decision is about costs, and I think that is an item where this judgment will be cited on in the future. It's a procedural thing, but it's a good reminder for parties that one should not incur or cause costs for the court and for the other party that are effectively unnecessary. So this is copied from the judgment. It's in German, but it's saying exactly that. If you cause unnecessary costs, unnecessary burden for the court and the other party, even if you succeed on the merits in total, and that's what happened here, both patents were revoked in first instance by the patent court. Even in such a case, you run the risk that you have to bear a certain amount of the costs, and here that exactly happens. The patent court explained that it's effectively unnecessary to bring 15 more or less identical novelty attacks against the granted claims, and 15 or 11 inventive step attacks in addition also against the independent claims as granted. That's just objectively unnecessary. That's what the judgment holds. And here the fully successful plaintiff had to bear 20% of the costs. So that's kind of a a thing to remind oneself of. Bring reasonable arguments, but don't bring essentially 15 times the very same argument. That's what I can tell you about this judgment. The next thing I have on my agenda is not relating to the Federal Patent Court. It's an 𝗵𝗂 thing. It's about the currently ongoing quality discussions at the 𝗵𝗂. If you follow me on LinkedIn, you might have seen this post that I have on the screen right now. There is an industry patent quality charter of very prominent heavy filers at the 𝗵𝗂. They say that the quality of the 𝗵𝗂 is really degrading, and they ask for certain information and countermeasures. And I think the discussion is currently pretty much stuck between the IPQC and the 𝗵𝗂. And I stayed out of this discussion for very long because, quality, what is quality? You ask different people, and different people have different opinion. That's always difficult to discuss, and I felt I just don't know the facts. There were strange office actions in the past 20 years ago, and there are strange office actions now. I don't count them. I cannot really say whether it increases or doesn't. I have a vague feeling it does, but I did not feel comfortable to enter into this discussion. That changed when I noticed a report in the Stuttgarter Zeitung saying that there were internal instructions at the EPO, essentially saying that the clarity of a patent is not a priority, and that inventive step is not to be examined in depth. That really troubled me, because if that internal instruction really existed, and was not just hearsay, it was really putting quality at a severe risk. I asked my LinkedIn network whether someone knew more. I, meanwhile, indeed got information. I got documents, and I will report about that maybe this afternoon, at the latest tomorrow, on the blog, and then again on LinkedIn. What I got as documents is really troubling me. And now that I know what is really sent as instructions or as recommendations to examiners in black on white, I happily enter into this discussion. Okay, that was just an outlook of what you might expect today or tomorrow on the blog, which is EPO quality thing. The next one is just as a final notice. I just realized earlier today that the Federal Patent Court is now on LinkedIn, which is really great. I think the Patent Court left actually Twitter a few weeks ago because it's really hard to read tweets when you don't have a Twitter account. That's just one of the amendments that Elon Musk introduced. One may like it or not, but I think the most audience in our field is in any way on LinkedIn, not on Twitter. Some are on both, but most are definitely on LinkedIn. So it appears that the Federal Patent Court is now on LinkedIn, so that might be a page that you want to follow. I did. With this being said, I'm through with what I had on my agenda for today. I can't see any comments or questions in the chats in the tool that I'm using. I'm just checking on LinkedIn. Apparently there are no questions or comments either. Well, if there is no point of discussion that you would like to raise, I will finish that LinkedIn live session for today. Hope you will join me next month again. If you have a point that you wish to discuss after that, after you listen and look again at the recording, just drop me a comment later or send me an email, whatever you wish. I will be happy to discuss anything of what I have presented today. So watch out for the LinkedIn post about EPO quality if you are into that topic too. It's not a patent court related topic, but it's an interesting one too. So I will leave it for that, and enjoy your lunch if you did not yet have lunch, and I hope to see you next month again. Bye-bye. Thank you for joining.